in electing their representatives reflect what the people have voted it to be. This is because, my Lord, sovereignty is exercised directly. It can also be exercised by the representatives they elect. So by sticking to the principles that guide the process of election, that's how it can give the sovereignty of the people the life it deserves. Under Article 81 and Article 86, the electoral process has to observe, among other principles, transparency. It also has to be an accountable process. My Lords, the Commission is constituted under Article 88, and the national legislation that provides for the Commission is the Independent Electoral and Boundary Commission, that is Act number 9 of 2011. Under Section 5, a commission is established, and under Section 11 and 11A, it's categorical that the Secretariat works under the Commission. So the staff of the Commission performs a delegated function. The buck stops with the Commission. My plain reading of Article 138(3)(c) is that the process of tallying, verification, and declaration of the result is the mandate of the Commission. It's not the mandate of the staff or the Secretariat. This is also reiterated under Section 39, 1C, paragraph B, which also states categorically that the function of tallying and verification is supposed to be done by the Commission. Was it done by the Commission? That is the only question, my Lord, I will answer. I will answer it through the eyes of the averments made by the 9th respondent, that is Professor Abdi Gulier, and the 4th respondent, that's in the consolidated petition, that's Honorable the Chairman Chebukati. This is how, from their own affidavit, without even going to the regulations in which they set out on how the verification was supposed to be done, from their own affidavit, when the other 4 commissioners are clear that they were not involved in the verification and tallying and declaration of the result, this is what they say in their respective affidavits. The affidavit of Professor Gulier, the 9th respondent, sworn on 20th of August 2022 in respect of petition 005, at paragraph 8, he is clear that once assigned a responsibility by the Commission, whatever recommendations he makes have to go back to the Commission for consideration. So from his own averment, it was clear that even when the Commission delegates a function to a commissioner, he has to report back to the Commission for approval. At paragraph 32 of his affidavit, this is how he described how verification was done and the result generated. That the Chief Executive Officer / the Commission Secretary came with the final result. That is on 15th of August 2022, when the commissioners were seated in a meeting. he acknowledges that the verification is not being done by the Commission. It is the Chief Executive Officer getting to the commissioners a result, a clear admission that they were not involved in the tallying and the verification of the result. Now, in respect of the 27 constituencies which have been mentioned, whether, and there was doubt whether verification was done, this is how he puts it in paragraph 27, paragraph 35 with this affidavit, that these constituencies were verified in the presence of agents of candidates and included in the final tally. There's nowhere in that statement it says that verification was done by the Commission. Now, on why he did not even announce the result for transparency, then he says there was no calmness in the auditorium for them to announce the result. But then the question is, when it was restored, the chairman of the Electoral Commission was able to read the result in Form 34C. The question is, during that period, how is it that they could not read the result for the 27 constituencies? The chairman of the commission, Honorable Chebukati, in his replying affidavit to the fourth petitioner's petition, the affidavit is undated, but it was filed on 27th of August 2022. This is how he characterizes the verification of the result by the Commission. At paragraph 31, he avers under oath that the verification and tallying was undertaken by a staff of IEBC with some commissioners assigned the role. My Lord, from the chairman's own averment, the verification is being done by a commissioner assigned the role, and the staff of IEBC. There is no indication anywhere that that outcome of the verification was brought before the commissioners before an announcement was made. It is understandable that tallying and a verification of over 40,000 polling stations is an Herculean task, and it cannot be done by 7 commissioners. But, my lords, if they delegate that function to the staff of IEBC and a commissioner or 2 commissioners, it is my submission that whatever report that comes out of that tallying and verification has to be placed before the commissioners before a declaration is made. My Lord, that was not done. Now, an explanation is given by the chairman of the commission at paragraph 25 of his affidavit in reply to the fourth petitioner's petition, when the fourth petitioner avers that no announcement was made for 27 other constituencies for purposes of transparency, this is what he responds: there was no legal obligation to do that. My Lord, there is no explanation given why it was done in respect of 261 other constituencies and not the 27 constituencies. It's my submission that in respect of those other 27 constituencies, there was lack of transparency and accountability. The chairman avers in that paragraph 25 of his affidavit further that Professor Gulie was prevented from reading the results, but there's no explanation further why he could not read the result for the 27 constituencies after calm was restored. And if at all tallying was already done for the 27 constituencies and a report prepared, my lords, this should have been included in the reply of the chairman to the petition to confirm that indeed the tallying and the verification had already been done. It's my final submission that the result that was declared by the chairman of the commission did not reflect the will of Kenyans, and it should not be let to stand. My colleague will take over the issue number 8. Thank you, my lord.
My ladies, my lords, my name is Dego Njiru, permit me to address issue number 8 in respect to our petition. And while addressing that issue, my ladies, my lords, I'll be seeking to answer the question whether or not the election that was conducted on 9th of August was a constitutional election. While I do that, my ladies, my lords, permit me to refer you to various affidavits, and I begin by referring to paragraph 52, paragraph 53, and paragraph 54 of our petition. I'll also refer to paragraph 51 of the Vice Chair's replying affidavit, that's the 5th respondent. I'll also refer to paragraph 25 of the Chairman's Chebukati's replying affidavit. I'll finally look at paragraph 19 of the second respondent's, William Samoei Ruto's affidavit. Why are these paragraphs important to these proceedings, my ladies, my lords? And while addressing that question, I am going to refer to various provisions of the Constitution. I'll begin by referring to Article 88 of the Constitution. I'll seek reliance again on Article 89, Article 97, Article 138, Clause 2. I'll also seek reliance on Section 2 of the Election Act, and I'll also seek reliance on Section 83 of the Election Act. My ladies, my lords, if you look at the affidavits that I've mentioned, and most importantly, affidavit by the chairman of the commission, at paragraph 25, he defines and says that he conducted tallying of election results in 291 constituencies. Paragraph 19 of Honorable William Ruto's affidavit, again he says that elections were conducted in 291 constituencies. The fundamental questions, my ladies, my lords, is how many constituencies do we have in this republic? If you look at Article 138, Clause 2, the Constitution provides that elections shall take place in each and every constituency in this Kenya. And when you define constituency, my ladies, my lords, you look at the provision of Article 4 and Article 5. Article 5 of the Constitution, which defines the territory of the Republic of Kenya. Then you further look at Article 89, Clause 1. It says there shall be 290 constituencies in the Republic of Kenya. And that is where the law contemplates that elections shall take place. But what happened on 9th of August is that we have submissions and averments that elections took place in 291 constituency. The fundamental questions, my ladies, my lord, is where did this extra constituency come from? And is this extra constituency a constitutional constituency defined by the armpits of Article 89? There may be arguments that this was a constituency by the diaspora. Yes, they may have their rights under Article 38 to vote. But the question is it a constituency within the meaning of the law? We submit that to the extent that individuals not confined to Article 89 of the Constitution, to the extent that the elections of an extra constituency not defined under Article 97 took place during that particular time, that contaminated the election. You must then ask yourself, to what extent was the contamination? Article 138, Clause 4 requires the Commission to compute whether or not the president-elect has attained 50 plus 1%. We are submitting that these elections that took place in alien constituencies contributed to the computation of 50 plus 1%. Then you might ask yourself, my ladies, my lords, what then is the test that I'm trying to apply? I am applying the test proposed by Section 83 of the Constitution of the Election Act. It provides that an election can be voided if that election did not comply with the Constitution or other written law. And this is a fundamental question, my ladies, my lords, because a constituency as defined by Article 289, Article 89, that must be within the territory of Kenya as defined by Article 5, then contemplates a situation whereby there is a question of representation. It subjects the people of Kenya to exercising their sovereignty through the representation of those people. The question then that begs an answer is, how can an election that has been infiltrated by alien constituencies be regarded as a constitutional election? We submit thus that waives the fundamental requirement where IBC under Article 88, Clause 5, is required to conduct an election within the armpits of the Constitution. It is a mandate within the IBC that the mandate is so fundamental that it cannot be waived, it cannot be fettered, it cannot even be relaxed. An individual cannot create a constituency. If it was in the interest of Kenyans, while promulgating this constitution and adopting this constitution, and giving this constitution unto themselves to create an extra constituency, there was nothing that was as easy as saying as such. My ladies, my lords, permit me to address the question of the 27 constituencies. Again, it has been submitted by my learned friend that under paragraph 25 of the Chairman Chebukati's replying affidavit, he has glossed over that weighty issue. He does not consider that 27 constituencies, which makes about 10% of the Kenyan constituencies, which translates to about 1.9 elected voters, were not included in the final tally. And what does he do? He makes and he amends and carefully uses the words which to apply. In his replying affidavit, he technically avoids the use of the word declaration and he uses the word announcement. The word announcement is not akin, is not similar, and does not mean declaration. Why, my ladies, my lords? Because Article 138, Clause 4, presupposes a declaration of all the polling results by the IEBC. So this declaration is not akin to announcement. And therefore, my ladies, my lords, we are submitting that the chairman of the Electoral Commission was lost on what he needed to do. He is making a declaration and reducing the question of declaration to the question of a master of ceremony. The IBC chairman was not called upon to just officiate the process. He was called upon to execute a constitutional obligation. And therefore, when the law speaks about a declaration, there must be clear demonstration that the same was done. What happened, my ladies, my lords? He says that the law does not require him to do so. He does not annex any evidence that the same was declared. He does not annex any evidence in his affidavit that there was tallying. He does not aid this honorable court to make an opinion that yes, the requirements of the Constitution were met. Finally, my ladies, my lords, we need to interrogate the conduct of the chairman of the IBC. We need to interrogate the previous and even the current conduct of the chairman. He was effectively described by my senior line friend, Mr. Norji, that is a person who has perfected the art of imperfection. And he has perfected the art of imperfection by making sure that he conducts a lone ranger process. Remember, my ladies, my lords, to the run-up of the second election in 2017, a similar issue arose, which necessitated the resignation of the commissioners. How long shall we allow an individual to keep on transgressing the law? How long shall we allow this individual to keep on putting Kenyans and to subject Kenyans into uncertainty? The law requires that there must be certainty. And the certainty contemplated by the law is that I shall cast my vote, and my vote shall count. And why are the 27 constituencies fundamental and key to these proceedings? If you look at our paragraph 57, 52, 53, and 54, we have listed those constituencies. It is where an individual or the first petitioner has his supporters. It is where he has his support base. So were they left out as a matter of design? Were they left out by default? Or was he holding someone's brief? My ladies, my lords, we submit that to the extent that those constituencies were not tallied, were not verified, and declarations were not made, then this election did not meet the provisions of the Constitution. Finally, my ladies, my lords, he says in paragraph 25 that he can announce elections anytime that he so wishes, even if there are some constituencies that have not generated their results. But what does section 39, subsection 2 of the Election Act provides? It provides, my ladies, my lords, I would wish to read this. The chairman may declare a candidate elected as president before all constituencies have transmitted their results. The operating word here, my ladies, my lords, is the word before. So if before, at the time he's declaring those elections, the constituencies have not generated their results, he can declare. But the situation where we are in, my ladies, my lords, on 9th, going by the dictates of Maina Kiai's case, the chairman had received all the results from the polling stations. It was therefore incumbent upon him to make sure that they are included, to make sure that they are tallied, to make sure that they are verified. Finally, my ladies, my lords, permit me to delve on an issue that was dealt with in the morning by my senior learned friend, Mr. Governor Orengo. My ladies, my lords, I am referring to the replying affidavit filed by Honorable William Ruto, and I'm referring to page 111, where it indicates a preliminary statement of the IGAD election observation mission to the August elections. At that paragraph, my ladies, my lords, these were individuals who are observers of the elections, who are out there observing the elections. When it came to the question of analyzing the voters' turnout, the report says, it is annexed in its affidavit, that in most of the polling stations visited, voters' turnout was noticeably low and recorded around 55%. Those were observers out there in the field observing the elections, giving a return of the 55%. And this 55%, and you can see how this computation of the turnout is fluid. It is so fluid, it's a lever. You are not able to hold it. The chairman is not able to tell about the voters' turnout. The report is giving us a different voters' turnout. So what exactly was the voters' turnout? So that the voters' turnout then can assist us in the computation of the sum of 50 plus 1%. Finally, my ladies, my lords, there's a question as to, there's a question as to the computation of the 50+1%. That when the chairman gave his final public address about the voters' turnout, he deliberately exempted those individuals who voted manually. To date, we are not aware of how many people passed through the manual registration. How many people voted manually? I mean, my ladies, my lords, it is not within the armpit or within the purview or within the power or the discretion of the chairman of the Electoral Commission to do that what he wishes. He cannot deal with the question of elections from his aspirations or from his wishes. He must deal with the question of election as dictated by the Constitution, as dictated by the election laws. Finally, my ladies, my lords, we urge you to admit our petition and you dismiss the replies filed by all the respondents and find that this election was not conducted in accordance to the Constitution. And my ladies, my lords, that you give an order that the sovereignty of the people must be respected. And the sovereignty of the people cannot be respected, cannot be upheld where there is serious transgression at the wishes of the chairman of the Electoral Commission. Finally, my ladies, my lords, there needs to be a retribution. There needs to be a stop of all these transgressions. How many times shall we subject Kenyans to these processes? How many times should we appear before you with the same gravement every day, after every elections? There ought to be a stop. And a stop is making sure that the proper sanctions, criminal sanctions, as prescribed by the Election Act, are meted against any transgressor. And there is no one who is above the law, including the chairman, so that people may learn to respect the law. I'm so obliged. I donate the 26 minutes to the court.
Thank you very much.
Seconds.
Those are seconds. Thank you very much, Council. As regards petition number 7, we have Mr. Mtata appearing for himself, and Professor is appearing for the other. So I think you'll share the time, Prof.
Yes, thank you, Your Ladyship. Well, our submissions will be in two parts. The first part will be qualitative, and I will address myself to the law and complement the submissions that have been made by learned friend, Senior Counsel James Orengo, learned friend, Senior Counsel Philip Murgor and Feroz Noroji, on the questions of compliance with the law and on the unconstitutional nature and the non-compliant nature that the first respondent, Mr. Chebukati, employed in running the presidential election of 9th August 2022. My lords, the person I do not want to be now is Professor Githu Muigai, because every single advocate in this court has spoken to the violations by his client. Violations, my lords, that border on the violation and speak to the violation of Article 3.2, the unconstitutional proceedings that led to the issuance of Gazette Notice 9773 of 2022, issued on 16th August 2022, that declared the president-elect. My lords, we shall be asking that that violation or that Gazette Notice be vacated as we make several orders, my lords, under Section 84 of the Elections Act and Article 143 of the Constitution. My lords and my ladies, let me start by submitting that my submission shall be around one, the issues framed by the court, particularly, my lords, issue number 8 on illegalities and irregularities that if applied disjunctively as this court has ordained before, my lords, will lead to a compelling order of nullification of the elections of 9th of August 2022. But I will also, my lords, and in view of the powers of this court under Section 3 of the Supreme Court Act, delve into the interpretation of Article 143. And my lord, perhaps because this court is also the jurisprudential head of the judiciary, to see, my lords, whether there are possible sanctions or possible findings that this court can make other than the order of nullification. And my lord, that will be in my last submission. My lord, let me just touch on the second part. The second part that my learned friend Mr. Omtata will deal with will be the maths, electromaths, the mathematics of the election. We will demonstrate by way of a PowerPoint presentation that none of the candidates met the 50% plus one vote as per the tallies that were read by Chairman Chebukati on the percentages weighed against the voter turnout and the votes cast, my lords. And that will show that if indeed no candidate attained the 50% plus one, then this court has a daunting task. One, of course, after the exercise that is ongoing, the exercise that is going on with the server, my lords, we will be asking this court, my lord, to think of the possibility of declaring a winner after the outcome of the access to the back end of the server. That's number one. But number two, my lords, patently, the results announced by the chairman of the IEBC were unconstitutional because they did not emerge from the commission. And granted, my lord, that they were unconstitutional, if the court then is unable to arrive at a result as to who won the election, my lord, then of necessity the court would then would have no option but to proceed to nullify or find that it was conducted illegally. My lord, let me just proceed because of time to the key submissions. My lord, it is patent and glaring that there was non-compliance with Article 81A and D of the Constitution, read together with Article 86E of the Constitution. The elections were not verifiable inasmuch as voting took place. The process of tallying of the presidential vote from the polling station and the issuance of Forms 34As transmitted to the Constituency Tallying Center and finally to the National Tallying Center, my lords, was not a verifiable process. My learned friend Philip Murgod has spoken largely to the access that two individuals had to the system. He had spoken of one Dahir and one Kwanusu, who had access over 1,000 times Mr. Kwanusu, the PA to the chairman, Mr. Professor Gidhu's client. Clearly, my lords,
I would like to request the Honorable Court that we conduct this petition in the tradition, in the very long honored tradition of each counsel arguing his case without any sideshow.
my lord, it is a fact that the chairman is Professor Gidhu's client, but I will, because of the discomfort,
Counsel.
Address myself to
Yes, I'm speaking.
Yes, my lord.
I think you should treat your colleagues with respect. We all know that who is representing who. So make your point.
My lords, I will proceed. I will proceed. I will not mention Prof's name going forth. But my lords, the violation is glaring in view, my lord, of the fact that the non-verifiability of the process from the tallying center as held by the Court of Appeal, my Lord, we've spoken to this severally, to the National Tallying Center of what each presidential candidate received, my Lord, is a subject of an unconstitutional act. My Lord, that is point number one. My Lord, therefore, the counting, there was a violation of the duty to count each vote cast by an individual as contained in the Form 34A transmitted to the National Tallying Center and as uploaded to the Form 34Bs and 34C that was used to declare the result in Form 34D, my Lords. My Lords, granted further, that violation is also reflected, my Lord, in the violation of the Elections Act itself. Because, my Lord, there was a requirement that once the tallying is done and the verification done under Article 138(3)(c, it was not the chairman, but the commission that was required to undertake that process. And my Lord, I want to speak to the affidavit of the chairman himself. Other advocates have submitted on the self-importance that the chairman presumed in conducting the final tally, ignoring the mandatory nature of Article 138(3)(c. This court has dealt with the question of interpretation of statutes and of the Constitution, my Lord, where there's a compelling word, shall. Article 138(3)(c is compelling in nature. It does not give the chairman an option of consultation or of assuming the role of the commission. It states, my Lord, that the commission shall undertake the process, not the chairman. The same term, my Lord, is used in the second schedule to the IBC Act and in sections 4 and 8 of the Elections Act. My Lord, if I may just read 138(3)(c. It provides, my Lord, that the process of tallying, my Lord, after counting the votes in the polling station, the independent electoral and our commission shall tally. My Lord, where shall is used before a verb, citing my learned friend, senior counsel, it leads to an inevitable and compelling option. And this is what the courts have interpreted in several cases that we have handed over to the court, my Lord. The cases in Kirain Investments and National Land Commission, this was the finding of the court, again citing the findings of the Court of Appeal on the same question. Wesley, Judge of Appeal, laying down the consequence of the use of the word shall as peremptory. So, my Lord, that of itself, any action reflected in the affidavit of Wafula Chebukati that denotes any action by himself in assigning other members work, my Lord, and in eventually purporting to act under 138(10) alone without consultation invalidates the entire result that he purported to announce and invalidates the issuance of Form 34C and D, in which he purported to announce the results of the election. My Lord, ipso facto, the duty to transmit, tally, and collate was therefore violated. The regulations, my Lord, 39(1)(c) of the Elections Act required two tallies, the physical tally and the electronic tally that ought to have been transmitted. Non-compliance, my Lord, is evidenced in the affidavit filed by Cherere and by the 4 commissioners, my Lord, and an admission by the chairman himself that the tally was not compliant with section 39 1D of the Elections Act. My Lord, going forth, the complementary nature of compliance reflected from sections 39 to section 44 uppercase A of the Elections Act, my Lord, denotes non-compliance by the commission, but also an admission, my Lord, that there was no commission the moment the commission was divided and was working in different forms. My Lord, Article 3.2 of the Constitution provides that there shall be no government established other than through the Constitution. So that any violation that leads to an unlawful process, my Lord, cannot stand. And this court has the duty under Section 3 and Article 140 to invalidate an offensive action that is unconstitutional. My Lords, we submit that through the affidavits that admit the interference with the transmission system, the interference with verification, and the duty to declare the presidential election by the commission, the result gazetted in Gazette Notice issued by the chairman, being Gazette Notice 9773 of 2022, was unconstitutional and cannot stand and must be invalidated by this court. My Lord, in view of time, we wish to submit that even aside finding that even the duty of the commission as created and enshrined, my Lords, in Article 249, is governed and dictated by the principles under Article 10, my Lords. And my Lords, where public officers do not act in a manner donated by Article 10, then their actions must be vitiated by the court. And this is the forum where such actions must be vitiated. My Lords, the law is clear. The maxim ex turpi causa honoratior action, which has been developed over the years, my Lord, by Lord Mansfield, initially in Holtzman versus Johnson, later in Tinsley and Milligan, and now in Patel versus Misra, speak to the fact that no circumstance can allow this action to stand. The opposing affidavits, my Lord, the opposing affidavits filed by the 4 commissioners and the 3 that speak to the violation of paragraphs 5 and 7 of Schedule 2 can only lead this court compellably, my Lord, to find that this is a matter that this court must handle in the manner that lex arbitri would dictate. My Lord, the principle, ex equo et bono, used by international tribunals to settle questions. In the local framework, my Lord, we refer to Solomonic wisdom in 1 Kings 14. The court should look at the opposing affidavits. The court should look at the misconduct of the chairman of the commission. The court will then compellably apply the dictates of fairness in this matter and find that the people of Kenya were violated by the conduct of an election outside the framework of the Constitution, through the violation of the process, through the violation of the outcome. And my Lord, we want to demonstrate to the court, before I wind up, that mathematically, and this is where the law meets mathematics, no candidate attained the 50%. If the chairman read the results that he read and the percentages that he read out of the registered voters that cast their votes, my Lord. My Lords, the maxim, amiable compositeur, that I shall look at after my learned friend, Mr. Omtata, presents the results, my lord, will show you that this court has no option but to nullify this election. There's no option. There's no option. Mr. Omtata.
Gather because you're all senators, you're learning friends now?
Yes, my lord, Mr. Omtata is a serial litigator and a public interest, a public defender in this country. And I respect him for that role, my lords.
And now a senator? And now he's a senator?
Yes, a senator for Busia County. He replaced the Attorney General, who did not run for office.
Members of the Honorable Court, in my submissions, I will rely on the petition we filed jointly with the three others, which is dated 22nd of August. I also have submissions which I filed alone, which are dated 26th of August. And I also have a further affidavit, which is dated the 29th of August. My lords, before I remark on the mathematics, I just wanted to make a small observation as regards point number 1. And I think the elephant in the room is point number 1. What kind of election does the Constitution of Kenya anticipate? That's a question that I've seen documents and videos by some members of the court telling me that even this court does not comprehend the kind of election anticipated under Article 81 and 86 of the Constitution. Short of a digital election, you cannot meet the constitutional threshold.
Mr. Mtata, what
Yes.
did you say?
I said I've come across publications and video recordings by some members of the bench who complain that the 14 days the court is given to determine a dispute concerning the presidential election is too short. And I'm saying that statement demonstrates the failure of, with due respect, the honorable judges of this court to understand the electoral architecture in the Constitution of Kenya 2010. The Constitution of Kenya 2010 only anticipates a digital election. And if we are dealing with a digital election, 14 days is too much. But if you are dealing with a paper election, a manual election, you need maybe 2 months. That's where I wanted to begin. And this election does not meet the threshold in the Constitution at all. The presidential election, the one I'm referring to, that's before this court. It's not simple. That's why you have got spoiled ballots. In a digital election, you don't have spoiled ballots or rejected ballots. And you don't even have the question of whether spoiled or rejected ballots count. It's not verifiable. Right now, I cannot verify where the ballots I cast went. I don't know. The moment I dropped them in that box, I lost all contact with those ballots. There's no mechanism of verifying. A digital election would give me a serial number by which I could track my ballots. So I'm saying that if you look at the threshold in the Constitution, we must work towards a digital election and move away from these paper elections, which allow human interference without sometimes leaving
footprints. I would now go to my submissions. I was supposed to be given some aid. Yes. Where the
If the time could stop running, we had supplied the electronic instruments to the court.
You beg the assistant.
I don't understand what you said. I come there. Oh, open for me the PowerPoint document. Go to the next slide. Yes, we're looking at an analysis of paragraph 26 of affidavit filed by Mr. Sunkuli in petition number 7, paragraph 226. And you can see that he's giving us, he gives data of how the KIMS kits transmitted on 9th August at 17 hours at the close of polls. He gives that figure. On 9th August at 20:45 hours, about some 3 hours and 45 minutes, he gives his figure of 13 million. Then, most surprisingly, you have two entries. There's the entry that which gives us at 14 hours and 14:40 hours. The KIMS kits are transmitting some 23 hours later, still transmitting data. And we're saying that that data is not acceptable. So we come to the next slide. I'll just run through given the short time I have. When you got that slide, you look, they tell you at 20:45 hours, on 9th August 2022, some 13,731,215 people voted. Polling turnout recorded on 10th August is 14,239,862 ballots. And on the 10th, that is the day after the voting, and we know that it's only elders where elections were taking place. Now, when you analyze that data, you find that 508,647 ballots are added on the 10th. And you saw Land Council Willis show that the audit of the register had almost the same number of ghost voters. So you can see from that data that Mr. Sunguli presents, you are able to isolate 508,647 ghost cast votes, which are more than the difference between the two leading candidates. If you go to the next slide. And if you look at the ballots that are recorded to have received, to have recorded on the next day, we are talking of some 1,665,412 curiously cast votes, which are coming out after the close of voting, and that's after 3 hours after the close of voting. So if we take the total tally now, you find that the tally is close to it's about 1.7 million votes. That spike in votes is not possible. That spike in votes is part of the problems we're having, that fellows were having access, the KIMS kits that were still transmitting data from locations that are not clear. Because the KIMS kits that were in polling stations, the voting stopped on 9th. And giving an allowance of 3 hours or 4 hours for people who are still on the queue, you would understand by why a KIMS kit would still be transmitting 23 hours after the close of elections is something that is difficult to comprehend. Also, my members of the Honorable Court, if you look at the Form 34C that has been published and interrogate the data there, if you look at the total of the variables ascribed to each candidate, the amount that you get is 110 votes less than the number that has been printed on that paper. Now, if you look at, that thing was boggling my mind. Initially, I thought it was a simple error of addition. But it has come out it was not a question of 1 + 1 = 3. Because when you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, yes, I'm on, yes, go to the next slide. Next. Yes, sorry, I forgot to, thank you for directing me. If you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, the total voter turnout in the table when you subtract from it, as given in the table, the number of rejected votes on Form 34, you get exactly that figure of 14,213,137, which in that replying affidavit they claim was an error of addition. But if you interrogate their raw data, you find that that figure is the valid figure. So the votes attributed to the candidates are fictitious. From paragraph 32 of Mr. Sunkuli's replying affidavit. So, when you go on to the next slide, I've reproduced I've tried to factor in the figure that Mr. Sunkuli gives, and when you add them, you get the 14,213,137. Yet, when you add the figures attributed to the individual candidates on Form 34C, they come to 14,213,027. That is not an innocent mistake. It is a situation whereby somebody has left a trail that they were working backwards from a certain figure which they had, and they were working backwards, and so they would going to get that. And most important, I would also refer to the affidavit signed by the chairman, filed by the chairman in petition number 5. At paragraph 95 of his replying affidavit, sworn on 26 August 2022, the chairman presents the exact figure of 213,137 are the total valid votes cast for all the 4 candidates. So if that is the figure that's coming from the raw data, that's the figure that's carried in the affidavit, then the values attributed to each one of the 4 candidates are fictitious and cannot count. And therefore, that Form 34C is an invalid document. Go to the next slide. Sorry, next. Yes, so in that slide I'm saying, we can only conclude that these figures, which form the content of Form 34C, are cooked. You cannot have both of them in the same document. And this court should not allow that document to stand at all. And the conflicting figures, and those conflicting figures for valid votes cast of 14,213,137,000, and the other one is the one when you add the values of the individual candidates, the 4 candidates, you get 14,213,027, is evidence that the results were worked backwards to achieve a desired or predetermined outcome. Therefore, the declared percentages for the 4 candidates, no, the votes attributed to the 4 candidates and the declared and the percentages attributed to them is all fiction. Now, I got to address the question of whether you can achieve, if assuming that what in the totality of the announcements made by the chairman, any of the candidates realized 50% plus 1 vote.
Just checking on the time.
Yes. There's no display for the time, unfortunately.
According to mine, time is over. If you could just finish your slides.
Okay, thank you.
Because they seem to have lost theirs.
Okay, so a further analysis of Form 34C on voter turnout, the chairman announced, and that issue has not been retracted at the close of voting. He was answering a particular question, and a journalist asked him, as matters stand now, what is the national voter turnout? And he said, oh, that one, I can deal with it. And he said, as at the time he was announcing, it was 65.4%. And according to what the KIMS kits had reported. And he expected that value to go up when all the KIMS kits had reported and the manual had been included in it. So when you calculate that against the total voter register, the national voter register of 22,120,458 votes, you get that the voter turnout as at that time was 14,466,799 votes. The next slide. So from Form 34, the tallies are ascribed in Form 34. You get, when you factor in the rejected votes, you get a total value of 14,326,641 votes having been cast. That is the valid plus the rejected votes. So when you get the difference between the two, the declared voter amount and what has finally been published in Form 34C, you find that a number of 140,138 votes were not accounted for. If you add those votes, now we add these votes to the attributes given to each candidate, because we are now ignoring the number published on Form 34C that are claiming was a mistake, but which I've demonstrated was not a mistake. Now, if you factor that number of the correct number of the addition, which is 14,213,027 plus 140,138 votes, you get 14,353,165. Using that as the denominator, you get that William Ruto gets 49.999692402%. And the reason we are going to doing these decimal numbers in the long form and not reducing them, because the winning vote is 1. And what's the percentage of 1 in 14 million votes? It's about 7 zeros before you get to any digit. So that's why we are keeping the long form. So when you round it off, you kill voters and you include new voters. So Raila gets 48.372118662. The next page, Wahiga would get 31,987, which would translate to 0.222856771%. Wajakoya at 61,969 becomes 0.4317447. And so now there are these other votes, the 140,000 votes, 140,138 votes. Since those votes were not, we don't know how the voters gave them to the candidates. We cannot randomly allocate them to any candidates. So they become the fifth variable here. Those ones amount to 0.976356086%. In the scenario, no candidate acquires 50% plus 1 vote that is required under Article 138 Clause 4, Paragraph A. And so, with those few remarks, I pray that the Honorable Court allows the petition and the other petitions, and then...
My Lord, I had intended to make the prayers in view of the jurisprudential weight of the mundane questions that I would want this court to consider.
Sorry, Senior Counsel. Can Mr. Omutata confirm? I'm trying to go through the record. This PowerPoint presentation you've just made, is it part of your pleadings?
It's part of my pleadings in a law.
Word for word?
Yes, word for word. But I'm just cutting for purpose of hygiene.
Okay, thank you.
I will do it.
Unless you are changing, that is not word for word.
No.
So if it's word for word, we don't need any other copy.
But of the most important is the father affidavit. Because when I did the first one, I did the petition, I did not have the information that came from Mr. Sunkuli's affidavit. So I would request the court to pay particular attention to the father affidavit. That's why I had the benefit to compute the figures with the figures that the commission supplied. That's all, my lord.
Thank you.
Compelling are the figures that finally mathematics finds its way into invalidating.
So, Agenda, you have no leave to address the court after time. Why don't you start from there? From where? From what time? Start from there.
Senior Counsel, we agreed on the ground rules yesterday. You